Welcome back to the Law Unscripted, where we talk about everything about the law and the legal system that you never knew,
never understood,
and no one ever told you. Today, we are focusing on negligence, what it means, what in the world is the definition of negligence, and how it applies with the law. I'm Virginia Tehrani.
And I'm Chelsey Rogers.
And we are with Tehrani Law, LLC, because you never need a lawyer.
Till you do.
Okay, first big announcement. Yes, we're so super excited. Is officially the law office of Tehrani Law, LLC has opened for business.
Woo, give some snaps. It's so exciting.
It is exciting. So January 1st of 2023, this is the first Tuesday of the new year, 2023. And it is, I guess, two or 3 days now that it's officially been open for business. I am on my own. We are with Tehrani Law. Chelsey is our legal assistant. She's still in law school right now, but she is working with the office. And assuming she passes the bar, we're going to hire her full-time as an attorney. But until then, you can find her working with us on the podcast through the Law Unscripted that we have here, as well as the Legal Weekly Wine and assisting with the business.
Yeah, check us out on our socials. You might just get a comment back from me, so you can like, follow, subscribe. We're on TikTok, Twitter, Instagram, all the major platforms, and we would love to, get some feedback from you. Any comments, likes, and shares, we really appreciate.
Yeah, so thank you. Thanks to everyone who's supporting us and following us. We are super excited, and our dogs are sort of excited. For those of you watching or listening, we do still have the dogs involved in the program. I've got to my left, I've got Willow, my little white Merle Cocker Spaniel, and Charlie, the golden Cocker Spaniel, just hopped off my lap, and he'll be back and forth. He might hit the microphone, but that's the way he goes.
I might try to bribe him. Charlie, come on.
He does love Chelsey. So you can see them live here, but you can even see them on the website. So www.tehranilawllc.com is the official website for the business. You can find us. You can find out all about what we do. I specialize in traffic accident injury law, and you can check us out there.
Yes.
All right. Down to business,
Down to business.
Okay. Negligence.
Right. Negligence. So let's go in the way back machine.
Starting from the beginning.
Right. So this is first semester of law school torts.
Yes.
Negligence. Now, if I can remember correctly, don't tell the bar examiners this, right? Like there's elements of negligence, right?
Yeah. And when we talk about, sorry about the microphone, when we talk about negligence, or the elements,
right,
we're talking about four things you have to prove. But of course, it's law school and the law, so they have to give it a fancy term. And the fancy term they have used is elements. What are the four elements you have to prove in order to show that someone is negligent? And it's really just, what are the four things you have to prove?
Okay. So Virginia, what are the four things you have to prove?
Hopefully Chelsey will know all of these things for the bar.
Okay. I'll start with the easy one.
Okay, go.
I'll start with the easy one. Duty.
Yes, duty. So you have to prove that someone had a duty of care.
Okay, that's the law school answer, right? Like, oh, you have a duty of care. What does that mean?
Okay, a duty of care basically means you're responsible for, here I am, the law school answer, for not being negligent. But here we're talking about negligence, and it depends. You have a duty to take care of somebody. I think that's the best answer for it, is you're responsible for making sure bad things don't happen to other people. Okay. So a doctor is a really easy discussion for duty of care. Is a doctor has a duty to do no harm, right?
Right.
They have to take care of their patients. They have to make sure that they're well, that they're getting well, that they're prescribing the right medications, that they're doing the right medical procedures, that they're taking care of their patient and doing no harm. So that's an easy example of someone who has a duty of care to another person.
So, and correct me if I'm wrong, from what I remember, That's a specialized duty of care. And there are certain relationships. So a doctor-patient relationship, I remember like a child-parent relationship has a different duty of care than you might have just for a stranger on the street. But
Absolutely.
even for strangers on the street, there is a duty of care. It's just like when you're driving, right?
Especially when you're driving. And that's us as traffic accident law. You have a duty to obey the rules of the road, right? If you get in a car and you drive, you were supposed to not only take care of yourself in your own car, but you were supposed to take care of the other people on the road. You have to not speed, merge correctly, drive correctly, not do something wrong that would hit another car, hit another person, injure someone. So you have, as a driver, a constant duty of care to other people on the road.
Right, even past the speeding, which would be a crime, civil, criminal. We talked about it a lot in the last couple of weeks, but things like operating your vehicle with caution, that's the civil part of it, right? And that's what would be, you have a duty to operate your vehicle in a safe way, which is kind of vague, but.
No, but I don't think it is vague. I think it's exact, is you do have a duty to operate a vehicle with caution. That is your job as a driver. And I think it's a good example of what a duty of care is, because it's to the general public. It's not to your daughter, your son, your patient. It's not the specialized one. It's just random person on the street. You have a duty to make sure that you don't do something really stupid or illegal that would harm that person.
Okay, so that's our first element, or our first thing, whatever
element.
We're call it.
It's right. The first element that you have to prove in negligence, that you had a duty, somebody had a duty of care to protect you or cause you no harm.
Okay, so what's our second?
The second element that you have to prove in a negligence case is that someone breached that duty of care. And again, that's really fancy terms. It's the law school terms of breach of duty of care.
I know. I didn't realize how much law school has impacted me until I'm trying to think of other ways to phrase this. And there's just a blank. I think it's taken over my brain. But so when someone breaches, that's that they didn't use their vehicle in a safe way. Use their vehicle? Okay. They didn't operate their vehicle in a safe way. Would be a breach, right?
It is. Yeah, it's when you messed up, right? You didn't take care of somebody. You were unsafe. You violated a law. You violated a rule. And because of that, and we'll get to this is part of an element, but because of that, someone was harmed. So you had a duty to drive safely. You didn't drive safely. You sped, you rear-ended somebody, you merged incorrectly, you hit a pedestrian. That's a breach of your duty of care because you had the duty, right, to care for others, to drive safely, not to do something stupid and not to break the law while you drove.
Right. Okay, so here's a small part because I know we've done our two elements, then we'll go to two more. But when we're talking about these elements, these are things you have to prove or you have to demonstrate to bring this cause of action, right? So what do you really use to sort of, I guess, what evidence or what do you put forward to say there was a duty? That seems pretty simple, but because we all have this, duty to each other. But what evidence would you use to say, oh, they breached this duty?
So especially, again, the traffic accidents, we do that, but they are easy. At least in terms of understanding negligence. And they're a very common type of lawsuit. A large majority of lawsuits, civil lawsuits, are for traffic accidents, right? Let's be honest, is how many accidents are there throughout the country on a daily basis? And then how many actually end up in court? It's a lot.
Right. So, and I think people are familiar with it. So is it essentially for that type of case, do you just say, well, there was an accident that shows that there was a breach of the duty? That simple?
Yes.
Okay.
Pretty much. That you simply, it's hard because a lot of people say, well, what is the one thing you have to show? Well, all I have to show is he was driving.
Right.
That's literally it. Is I say, okay, in my opening statement, John Smith was driving on the same road as my victim, Jane Doe. That establishes immediately that because he's a driver,
he has a duty.
He had a duty of care. He had a duty to drive safely. As a driver, he had this duty. He crashed into Jane Doe, he breached that duty. He clearly did something that violated the law, violated the road rules, violated just the duty of care to watch out and drive safely and not injure or harm somebody else while you were driving. It's much more simple than they tell you in law school. In law school, they're going to give you 20 different cases where it looks like you have to prove to the jury a very, very specific thing and put up spreadsheets and, demonstrative aids. All I have to show is he was a driver and he crashed.
Right. I think that negligence seemed so complicated in torts. One, because anybody who's taken torts, it's like all of these cases from the 1800s and lots of railroads, people doing lots of things on or near train car tracks, and then having the most preposterous sort of injuries. Like that sums up torts. And so they use those to try and demonstrate negligence. But I think negligence could be taught in an hour if they would have just used a car accident case.
It's, and that's why we're doing this, right? As in law school, it seems so very complicated. And in practice, it's not. It really isn't. Are you a doctor? Okay. You have a duty of care to your patients.
What would a reasonable doctor do?
Exactly. What would a reasonable doctor do? What would a reasonable doctor not do? How are they supposed to take care of their patients? That's a duty. They didn't take care of the patient. That is a breach of duty. You're a driver. You have a duty to other drivers and people on the road. You hit somebody or another car or another vehicle or whatever it is, you breach that duty. It is truly that simple. Yes, you're going to get these random railroad cases. You're going to get some that are a little bit more complicated. But for the vast majority of lawsuits brought in America, the first two elements, the first two things that you have to prove in a negligence case are pretty simple.
Yeah, and so there's not a lot of argument. Okay, so what are our next two elements that are a little bit more difficult?
All right. And before we do that, negligence. I think negligence on the whole really needs to be defined because we're talking about what you have to prove for negligence. But negligence is basically you saying that someone did you wrong.
Right.
That I, as a plaintiff, I am someone who was hurt and injured and somebody else did it.
Right. Somebody else's fault, whatever has happened.
Yeah. And that's negligence. So that's what you're saying is I am saying that someone else did me wrong. And as a result of that, I am injured. And that in itself is a negligence case.
Right. But it's not the same as something would be like an intentional. They intentionally did this. It's sort of the only other option, right? Like they unintentionally did this, but it negatively impacted me in this way.
Right. So if you go out and you assault somebody, that's a crime.
And an intentional tort.
But it's also an intentional tort, which means you can file a civil lawsuit for assault and battery, but you're proving that they intended to cause you harm and then did cause you harm.
Right.
In a regular negligence suit, which is the only, like you said, the only other option, it's either an intentional tort where you meant to cause someone harm, or it's negligence where you cause somebody harm. It wasn't that you meant to run over somebody on the side of the road.
Whoopsie.
Right. That's not what you meant to do, but it's what happened as a result of the way that you were driving.
Right. You were, right. Like an intentional tort. It's like 10 points for pedestrian, right? But like negligence is like, I was just, daydreaming and caused an accident.
Yeah.
So what's our third element?
Okay, so
this is the biggie,
duty,
right?
Breach of duty, and yes, the third one is truly the biggest and most complicated and where I think most of the negligence cases get stuck or there are a lot of issues and ways of proof that do cause the 20, 80, hundreds of case law, cases that become law as to what is this? And this third element, this third thing you have to prove is causation.
Yes.
So what do you think causation is?
So if hello, Charlie. So sweet. I'm so sorry. I'm easily distracted by dogs. But so causation is saying that whatever your action or really with negligence, lack of action generally caused whatever injuries I have, whatever damages usually, right? You're saying that, it was because you were negligent that my car is now damaged. It was because you were negligent that I now have to go see the chiropractor or whatever that is, right?
Exactly. So the way that we phrase it in law is a but-for relationship.
Right.
But for your actions, this would not have happened. So if you had been driving safely, this would not have happened. Because you drove unsafely,
This happened.
I am now injured.
Right.
So
It's like that direct causation.
yes, exactly. You did this, so I am harmed. That is the causation. There is no other way. This is exactly why I'm injured, which leads to the fourth of damages. So I am damaged. I'm injured. When you're looking at it, duty, breach, causation, and damages, it's easy to prove damage.
Right.
I'm injured.
There's
right?
medical bills. Right.
Exactly. I have medical expenses. I have lost wages. My car was totaled.
Right. And that's easy to
damage.
prove.
Right. You have pictures. You show up with a photograph. Here's what my car looks like. It is completely totaled. I cannot use it. My door came off.
Right.
That's damage. Here I am in the hospital. Here's the cast on my arm. I am damaged. But what caused that damage? That's the big question, like I said, that a lot of cases get hung up on.
Right. So I think that the easier example, since we're using traffic accidents, I think the easier example is like a pedestrian car accident, right? Yeah. If the pedestrian gets hit by the car, they're going to say, your reckless driving or your negligent driving caused my injuries.
Yeah.
And spitballing. But the insurance company is going to say, well, you were jaywalking.
Yes.
That's the defense, is saying, well, it wasn't my negligence, it was your negligence, right?
That's exactly right. So the pedestrian says, this is clear. I wasn't in a car. I was walking. This guy was a driver. He had a duty to watch out for people on the road. He breached that duty because he didn't watch out for me. I was hit.
Right.
He hit me. That's a cause. And the driver says, well, I wouldn't have hit you if you had been walking in the crosswalk. Right. I didn't know you were going to step off the sidewalk in the middle of the road where there was no crosswalk. So really, this is your fault and you caused the accident.
Right. And that's hard to prove. You know, maybe the pedestrian one is a little bit more clear, but if there's two people driving on a highway and get into an accident, how do you prove who was being negligent?
That is the trick. Is, if especially in lane change cases, these are one of the hardest types of cases to prove for traffic accidents, is who had the right of way.
Right.
Which car should have been merging, which car merged into the other lane at an improper angle, at an improper time. They're going to be pointing fingers. I had the right of way. I could merge into your lane. You didn't let me merge, and you caused my accident.
Right.
The other guy says,
no, I had the right of way.
You weren't supposed to be merging. I stayed in my lane. I didn't speed up. I was properly there. You merged into me. And the judge or the jury has to decide which one of them caused the accident.
Who do they believe, essentially?
Yes. Credibility.
Yeah. I mean, now I think it's maybe a little bit different because there's traffic cams everywhere. There's businesses that have cameras outside. But I can't imagine, even just 20 or 30 years ago when there just weren't as many cameras out in the world, that it really was he said, she said about who caused the car accident.
It is, but it still is today.
Mostly that.
I mean, you have traffic cameras, you have other cameras, but let me tell you, trying to find them, get them, keep them, make sure that they actually were working properly is much harder than it seems. My clients come in and they say, oh, the bank across the road had it, or surely the traffic light took it, the police cameras, where? And did they keep it 30, you just came to me 30 days later.
Right.
It's probably written over. I have to find the right agency to contact to say, hey, do you have the camera video?
Request it.
Do the request, hope that they have it, hope that they turn it over. I don't yet have a subpoena. So yes, there are a lot more cameras and a lot more videos out there, but whether I have access to them is a whole nother matter. And in the end, it really still comes down to, what does my driver say versus what does the other driver say as to who had the right of way?
Yeah, I feel like we've had a lot of cases like that.
We have. And like I said, especially with the lane merge cases, those are really hard to prove. And it's why a lot of plaintiffs' attorneys don't necessarily take on those cases is, yes, I believe you, but Charlie's being super cute. You probably can't see him in the camera the way that we have it set up. But he is definitely getting himself comfortable on the couch next to Chelsey.
Yeah, Phil snuggled in.
So we have, the judge is having to decide. And if it's maybe it could be my driver who's believed. It could be the other driver who's believed. And because it's such a huge risk, a lot of attorneys don't like to take that risk because they can never guarantee money. They can never guarantee that their side will win, but it's a much bigger chance of a loss than it is of a win. Yes.
Okay, so that's causation. I think that makes sense. You have to prove that this person's actions are what caused the accident or whatever the negligence claim is.
Seems simple.
It would seem simple.
It does, but you go ahead.
But it's the proving it that's hard, right?
It is for a lot of cases. We mentioned this very simple example, but in a lot of other cases, we get into much more complex areas of causation where we'll talk about a surgery. Right. There's this horrible case. I remember it in law school, and maybe you saw it, maybe you didn't.
Maybe. Okay, let's see.
But the surgeon who left a sponge in a patient. Do you remember this case?
I do. I do.
Okay, so for those of you who
Those
aren't in law
freak
school,
me out. All of the surgery ones freak me out. I hate them.
Terrible. Yeah, the medical malpractice, the medical negligence cases is this famous one of a doctor who operated on a patient and for some reason left a sponge in the abdomen or whatever it was, closed them back up. The patient comes back, something's wrong. Well, nothing's wrong. And I don't remember how long it was later that they finally found out that it was a sponge that was left. So it seems awfully clear that this is negligence, right? The doctor had a duty to keep the patient safe and healthy, do no harm.
Yep.
They breached that duty by leaving a sponge in the patient, right? You're not supposed to have a sponge in a patient.
That's not the intentional thing, right? They didn't mean to, but it's still negligent.
It is. It's something that shouldn't have been done. It was, whether it was by improper oversight, just not paying attention at the end, whatever it was improperly done. And it ended up causing extra harm to the patient. Yes. So in this case, they had to prove that the surgeon's actions by putting the sponge or leaving the sponge in the patient was the cause of the extra injuries because they had so many medical complications and problems with the sponge still being in there. And think about it, they had to go back through another surgery.
Yes.
That's another set of damages.
Right.
Is a whole nother surgery.
Right. And I think that, at least from what I've seen working with you, is that anybody who has had any medical treatment for anything prior to whatever accident or claim they're bringing now, that becomes defense material. Well,
absolutely.
Sure. I'm not debating whether or not you had this treatment, you had these injuries, but I'm just saying it wasn't from this accident. It was from this other thing, right?
Yes. And that's where we get into the real complications. So there's the easy traffic accident, the fairly clear medical malpractice, but let's drop in exactly what you're saying. We'll have a victim of a traffic accident who had prior back problems. Okay. This person had prior back problems. They'd been to a chiropractor before. They'd had a couple of PT sessions, physical therapy sessions. They weren't feeling that great. Traffic accident happens. They now have back problems. They go to another physical therapist. They have more physical therapy. They say, hey, this traffic accident caused my back problems.
And they say, whoa, you were seeing a chiropractor before the date of this accident.
Yes.
Can you specify which pain came from which accident? Which obviously you can't.
Usually, well, yes and no. Not obviously. But possibly.
Right. I just feel like it's harder, right? Like, especially for people who are not medical professionals. If you say, explain your back pain from this incident versus explain your back pain from this incident. It can be like, I don't know, my back hurts, right?
And that's true, is a lot of people are like, well, my back hurt before and now it hurts again.
But different.
Some people, if you're really good as a victim, as a witness, so to speak, and what I try to do with my own victims is say, okay, look, I get it, and I agree that your back hurt before and it hurt after. I need you to think of any other words. Don't make them up. Don't invent something. But is there a way that you can describe how it was feeling before that is different, if it's different, than after the accident? Did your back just hurt and it was kind of stiff before, and then after the accident, it was searing pain? It was pain that went down into my leg that wasn't happening before. But if they can find a difference to explain, that helps with causation to say, okay, there was some kind of pain before,
right,
but as a result of the accident, that caused additional pain, new medical care, and new medical expenses that would not have been incurred if this accident hadn't happened.
Right. And I think that goes towards a legal skill of whoever, if you're doing this at a trial, whoever's directing, the attorney who's asking those questions on direct, asking the right questions to get those specific responses.
You have to ask the right questions, and you have to talk with your client before you just throw them on the stand in front of the judge or the jury.
Even when you do, they might say some funny things.
God bless. They really do. You can prepare and talk with your clients ages before and as many times as you can possibly think of, and they still surprise you with what they say on the stand.
Yes, I think something that I didn't realize, it always seemed strange to me prior to law school, that I was like, well, why would you need to prep a client for the stand? Because I was like, they just need to tell the truth. You're just going to get up there and ask them questions.
Which they should.
Should
be easy, right? Tell the truth.
Truly. I'm like, this should be simple. Like, I don't understand why people need to meet with their clients. That just seems off to me. Let me tell you. I completely understand it. Because I've seen you just go over when people have extensive medical records, you just kind of review them. Sometimes these trial dates are years after the accident.
Correct.
So it's not even that you're like, oh, you need to say this. You're just kind of going through their medical records, reviewing what happened.
Right. You need to remember, if it's been 2 years, you won't remember the exact words that you used to describe your pain. You won't remember, was it a level 9 out of pain or a level 7 out of pain? And it's not that you're lying or you're making it up.
Remember.
You just need to review and remember so that when you're on the stand, you don't say,
Yeah, it makes so much more sense to me now, because before I was like, well, you just tell the truth. What is there to prep? But now I kind of understand it more. And then even seeing after just a review of the records, a basic prep, they'll get up there and just say something different.
They will. And
out of left field. You just never know what's going to come out of their mouth.
You really don't. And
relatable. I feel them because I just never know what I'm going to say next.
And you don't. And that's why you have an attorney, is to, try to rein them in, try to make sure that they're keeping to the information that's relevant, the information that they need to share. My mom, I love her to death, but she would be the worst witness in the world. I cannot imagine putting her on the stand because she says everything. Well, it would be, I was driving down Greenland Drive and I was thinking about my brother's mother who...
But then I had to change the radio station because a song came on that I just didn't like, but I had to go to the grocery store, so then I changed it back because I wanted to hear the weather report.
And then somebody hit me and I couldn't understand what was happening, and I was thinking about my groceries, and it would just be on, and it's not that it's bad and it's not that it's wrong, but it's way too much information, and the judge and the jury don't need to know about the radio station or about your mother's brother or about the grocery store.
Yeah.
They need to know, where were you going? How were you driving? Where were you driving? On what road were you driving? And then what happened?
Right.
And she needs to say, I was hit. And the next question needs to be, okay, by whom? And that's it.
Yeah.
But it's people who like to share extra information.
Because they're being authentic, even though I can see clearly sometimes it's just not necessary. I think those are my favorite, specifically when we have like not directs but depositions with people who like to talk. I enjoy them. We have some characters that I think adds a little spice, a little flavor.
They do. I love my clients. They're so interesting. Yes. And for all of the hard stuff that we're dealing with, I mean, car accidents are really tough and injuries are extremely serious. So having the ability to view these accidents, these injuries, the victims, and even myself in a more lighthearted way of, we're not laughing at people. We're not laughing about injuries, but saying, okay, this is a really odd situation.
Yes.
This is an interesting piece of it. I'm odd. Let's put all of these odd pieces together. And isn't this fascinating? Isn't this a really interesting case, a really interesting person? And how do we present all of these amazing, wonderful pieces of interesting people, interesting facts, and very odd scenarios to a judge or a jury where we can say there was a duty, there was a breach of duty, they caused this, and now I'm damaged.
Yes. So I think what you just said is the most interesting part to me, is that how do you take all of these elements and the facts and your client and present them in a way that's the strategy. We've talked about it before, sort of the art side to the law. And I don't know about you, but I know the most famous negligence case, right? And I'm sure everyone out there is like screaming it, right? It's the McDonald's coffee case, right? I think the story and the kind of narrative that's been changing, but was, oh my God, the plaintiff, spilled some hot coffee and got millions of dollars, right?
From McDonald's.
They're just going after deep pockets, right?
It is. And the story, especially growing up, is, well, that's stupid. That's crazy that someone just spills coffee on themselves.
Come on, you didn't know the hot coffee was hot, right? But that is legal artistry and how it was presented and how it was framed, because the facts of it are quite different, right?
The facts are really quite shocking. When you actually get into the case, in looking at the damages, they were extreme.
She had skin grafts.
Yes, on very private areas. So for this woman, it wasn't a joke. It wasn't funny. It wasn't, I just spilled coffee on myself. It was, yes, I spilled coffee, but while I was driving in the driver's seat in areas that nobody wants to have coffee spilled on, and on my legs, my thighs, my private areas. And it was so hot that I had third-degree burns and had skin grafts. Who has coffee that hot? And that was the essence of the lawsuit, of how hot that coffee was. Is it hot or is it burning?
Yeah, and I think that was the interesting part, is that because it is this big company, they do have standardized requirements, which I think maybe makes a negligence case easier, of them saying these are the expectations. And it lists, coffee needs to be served at this, this temperature, all of those things. And I think that makes it really easy to say, well, your company requires it. It wasn't that. So there clearly is that breach, right?
Right. If it's a company standard, then you say you held yourself out to this standard. You breached your own standard. That caused my injuries. So you're liable.
Yeah.
You owe me for the damage that you caused. The harder question, though, is there an industry standard? Let's go outside of McDonald's. Is there a standard for Burger King, for all of fast food, that says this is what the temperature should be, and you didn't have it at that temperature? Or should there be a standard?
Right.
And it should have been a standard. You should have held yourself to that standard.
Right.
And because you didn't, there are these significant serious injuries.
Right. And so that comes to our fourth element of negligence, which is the damages, right? So if I say someone has a duty to operate their car safely, they didn't operate their car safely, it caused an accident, but there are no damages. I have no medical bills. My car doesn't even have a scratch on it. you don't really have a case for negligence, right?
That's absolutely right. And it's a perfect example because, okay, you had a duty, you had a breach of duty, you had a cause, something happened, there was a wreck. But if I wasn't physically injured and I had no medical bills, just like you said,
Right.
I had no lost wages, there was nothing on the personal physical end that I had to do, then that fourth element isn't met. I didn't have any personal damages.
Right.
Maybe you have property damage still. Your car was damaged. Okay, you go after the property. But if you weren't personally injured, the negligence for a personal injury.
If you just can't do anything.
Correct.
Gotcha.
So, and that even happens in medical cases. And these are the really tricky ones, is there was a breach. There was a cause of an extra surgery, something like that. But was it negligence or was the damage, well, that would have happened anyway?
Right.
Because of the injuries, the condition, the disease that you had, well, maybe you would have had another surgery anyway. So was that really a damage? Maybe you would have had another nerve injury. Was that really damage that was caused by somebody else?
Right.
Or is it just that's you? That just happened to you. It was a natural progression of whatever disease and ailment that you had. And that's where the damage piece comes in, is did it cause damage that you would not have had or you didn't have before?
Yeah, so the damage has to be specifically related to that incident, right? Like incident's almost the causation for, okay, the negligence caused the accident, crash, surgery, whatever. But are the damages you're claiming also a direct link to this incident, right?
Are they related? Yes.
And that could be harder to prove than you would think. Like I said, I think of just all the different clients we've had who have like pretty minor sort of pre-existing conditions. Like they're just pretty healthy people, and they've maybe had, in their lifetime, one previous car accident or whatever.
Right.
And that kind of becomes relevant now, even though it's kind of, from my opinion, like eye roll. Is it really relevant? I don't think so. But it does when you're sort of making these arguments in front of
it's a defense.
judge. Yeah.
That's what the defense has to do, is pick away at it of, okay, you're damaged, but is it really because of this accident?
Right.
Is it really because of our negligence? Okay, we were negligent. But is that why you're really injured?
Right.
My favorite case, and this is, you're going to laugh. My favorite case is actually, it's a real and a fake case. I was in mock trial in undergrad a very long time ago at Middle Tennessee State. And then I had mock trials in law school as well. But my favorite mock trial case was one that was based on the Mount Everest disaster in 1996. Do you know about this?
No.
It's okay. I'm old, but I think a lot of our listeners and viewers will, because it is the Into Thin Air is the book that was written by John Krakauer, who was one of the climbers on Everest in 96 when this disaster occurred. And he wrote Into Thin Air to describe what happened. It was about the whole trek, the trip. And it honestly is my favorite book. It's my absolute favorite book of all time. It's a biography, so to speak. And I think I keep reading it, trying to understand what in the world happened.
Okay.
Why would people even climb Everest? I don't understand that.
Really? You would? Are you telling me if you had the chance, you would not climb Mount Everest?
I am absolutely telling you that. I
Virginia.
might as well write a will and sell all my stuff and go to Everest, because I'm going to die. That is me. If it's someone is going to die on Everest, it is going to be me. I'm not going to go.
Really? Like if someone was like, came up to you today and said it's all of the gear, fully expense paid, you just have to say yes. You would be like, absolutely not?
That's exactly what I would say.
Come on. I don't believe that. I don't believe that.
No, it's absolutely true. I know too much about Everest in reading, in having this case.
That's true.
I was a voracious reader. I read the Left 4 Dead book. I read K2, everything. Okay. I read everything about climbing mountains, and especially Mount Everest. And this case followed it, where it was saying, okay, here are these two groups that went up to Mount Everest. Here are these people that went. And it was absolutely fascinating, where it was a suit for negligence against one of the guides.
Oh.
Where a wife had brought it on behalf of her dead husband.
Okay.
Who had hired one of these guides who had said, hey, I'll give you all the equipment, all the gear.
Yeah,
I'll take you up like the yellow brick road up to the top of Mount Everest.
Oh,
Okay,
no.
so the case, like the real events in the book, and by the way, it's the subject of two movies. There was a movie shortly after 1996, I think 99, called Into Thin Air, that was made about it.
How did I just completely miss?
I don't know. And then there was the second one, more recent, within the last decade, called Everest. Keira Knightley was in it.
Maybe I've seen it. I don't know.
She was the wife of one of the guides who died.
I don't know.
Anyway, I swear this is all relevant to negligence.
Right.
But a little background.
See, I just have blind confidence. Like, I feel like if someone was like, look, we have the supplies for you, you just have to say yes.
And Chelsey would die.
I couldn't say no.
I might actually survive because I know more about it and what not to do, whereas Chelsey would just climb the mountain.
Because I couldn't say no. Like, fear of missing out. Like, complete FOMO.
FOMO.
Like, I would regret it for the rest of my life. I was like, well, if this is how I go out, this is how I go out.
Into your generation, it really is. So please don't climb Everest. And if you do, I'm going to wish you luck. You will no longer be employed because you're not coming back.
I mean, fair, to be completely honest. And out of all the adrenaline sports, I think that's like the one I'm least interested in. It seems really cold.
It's very cold.
Like a lot of work. Like jumping out of a plane, you just have to get strapped to somebody, right? And you can jump
it's
out.
done, one and done.
Right.
It's quick. It's over. You're either alive or you're dead within, an hour or less.
You know, Everest seems like a bit of a commitment.
It is. Yeah, it really is a huge commitment. You're killing me today.
Okay, but this negligence.
Yes, the negligence with this. It was a suit based, a fake suit for negligence where the widow was suing a guide who had brought her husband up into this climbing group and had led him to the top of Mount Everest. And while on this trip, he died. And she was saying this guide had a duty, right, to my husband. He signed up with this guide who told him he would be responsible for leading him all the way up to Everest and taking care of him, including with the oxygen tanks, all of the gear, the yaks, the Sherpas, everything else.
Right.
And he would safely get him there and down. So breach of duty is he didn't come down.
So, okay, I do have a question about this. Not knowing much about this. I would assume, like, anytime you do something that can be dangerous, right? Like, there is sort of an assumption of a risk, right?
Yes.
I know anytime I've done something
nice
dangerous.
Legal word.
Look at that. I might actually be a lawyer one day.
You might pass the bar. Everybody stay tuned. We're going to walk with Chelsey through the bar.
That'll be an experience.
Yes, it will.
Okay, but so this was my question. That you generally sign some sort of liability waiver. And I know just from law school that doesn't mean that type of waiver does not absolve people completely from liability. Learn
Not
that in
completely.
contracts.
Yeah.
Got that. But something like this, can you really say the standard, right? Like the duty that we're going to hold you to is ensuring someone stays alive?
That is a great question, and that was the defense.
Okay.
That's the defense in a real lawsuit like this.
Yeah.
And in the fake one was, dude, you went to Everest.
Right, that's
Did you not
inherently
know?
dangerous.
Exactly. It's an inherently dangerous activity. You were climbing the highest mountain in the world. The first people who tried died.
Right, I would think that
I mean,
like
they
the
didn't even make
causation
it?
thing, it's not. But for negligence, you would be alive. You could be perfectly follow everything by the book, have all of the, oxygen tanks, everything, and still die, right?
Yes. You could fall victim to hate and haste, this high altitude pulmonary edema,
Right.
high altitude cerebral edema. I can't prevent that from happening to you.
Right.
You just got it.
Right.
That's you. Your body didn't handle the lack of oxygen very well. So, but for your hate and your haste that you just happened to
Right.
get, you wouldn't have died.
Right.
And that's exactly the defense
Okay.
is you assumed the risk. You knew it was a dangerous activity. You knew you could die. Seriously, even though you don't know anything clearly about Everest,
No.
do you at least know that there are bodies
There are markers
still there?
So I do know this, that the people who, again, trek on these hikes, that the bodies that have been there for decades serve as markers on your way up and down. I do know that because that seems wildly morbid to me, and I'm slightly fascinated by it.
But it is, and that's the reason I'm so fascinated with this too, is it is morbid, but it's absolutely fascinating, is when you have bodies as your mile markers, go past this blue one, how is that? Why do you do this?
Right.
And if you know that is assuming the risk is like, okay, I'm going to jump out of an airplane. I know I could die. I'm assuming the risk.
Right.
But the question in this case was, all right, I've assumed the risk of climbing the mountain. But because you decided to do the trek to the top at a specific time of day, on a specific day, when a storm was coming, is that action enough to remove you out of the assumption of risk?
Because you knew or should have known. Like if you're an expert, you're holding yourself out as an expert.
Yes.
You knew or should have known that was an increased level of risk, right?
Yes. And because you should have known, you put your climber at a higher risk of death or bodily injury by choosing that day, that time during that storm to still do the push to the summit. And because of those actions, not just the climb.
And he's dead, so there's no way to know if he consented to that additional risk, right?
Right. And how would you know if he knew that additional risk? The expert,
No, that's what I'm saying.
guide is the one who is supposed to have the information.
I guess I'm imagining this like in a movie style, like Hollywood set, where the guide is saying, I mean, we can get up there today, but it's going to be an extra risk. And you have this dude who like clearly likes adrenaline, like he's climbing Everest, right? He's like, full send, let's do it, right?
Yeah.
This is what I'm imagining.
I have to get to the top. I've
That
paid
would be me.
$60,000 to get to the top of Everest.
Right.
I'm going to get to the top of Everest.
Yeah.
So is it the person who just said, to heck with all of the risks, I'm going to get to the top?
Right.
Or is it the guide who said, I can still get you to the top?
So that's what they argue about in court, right?
Yes.
That's what it comes down to.
What it was is where is that causation? Where are the choices and whose expertise was followed? Did you follow the guide? Did you not follow the guide? And was the guide's information improper and negligent?
Okay, that makes sense.
And in the end, who caused it? Was it ultimately the mountain? You got haste? You died of altitude illness?
This is such a small detail, but I think it would be important. Did they bring his body down?
In the mock trial case, they did not.
Because I would think that would be important because then you don't know how he died, right?
Correct. You can't
That's
do an
a little
autopsy.
mystery for a mock trial.
It is. You can't do an autopsy, so you don't have a medical examiner who says, "Oh, he got haste, he got frostbite, or whatever." But in the end, there's the idea of, well, he froze to death in some way, whether it was actual freezing, whatever the cause. It's clearly altitude related. It's clearly climate related, temperature related.
Yeah.
The question in a negligent suit is who caused it.
Right.
But for
that makes sense.
whose actions this would not have happened.
Okay.
Would he have made it down?
No, I feel like that makes sense. Like you said, it was skydiving, which I've done. I signed
Of course, Chelsey has done that. Yes, of course.
Yes, it was super fun. But like when I signed the liability waiver, it was with the understanding that because the first 3 times you skydive, you have to do it tandem. So you have no control. You're just literally like strapped to some guy's stomach. Like you're just hanging out.
Right.
But my understanding when I signed that waiver, and it was true, obviously I'm alive, it was signed, is that these people are experts. They show you their certifications. But if for some reason I had signed that waiver and then we get up in the airplane and the dude's like, actually, it's my first time too, then I would sue them, right? Like that.
If something happened to you, then yes.
Well, yeah, that's what I'm saying. So that's a different risk than what you think maybe you're agreeing to.
Absolutely. And that's a really good example of maybe they were an expert,
Yes.
but they didn't properly prepare the parachute.
Right.
well, you didn't consent to them negligently preparing the parachute where when you pulled, it didn't come out. And now you're dead and your family's suing on your behalf. You clearly, according to what your attorney says in front of the jury, is she clearly didn't consent to an expert
not behaving like an expert,
not properly fitting out a parachute.
And
that wasn't an assumed risk. The assumed risk was skydiving is an inherently dangerous activity.
Right.
But it's especially dangerous if your expert doesn't properly prepare a parachute. You can't sign that liability away.
Right.
And that's the negligent behavior but for this person properly preparing the parachute that should have saved you.
Right.
You had no parachute. You went smush. You are now dead. That's your damages.
And so just to make sure, to demonstrate that in court, say we're, full trial, to demonstrate that, you would have other people who are skydiving experts come and say, I, as a reasonable skydiving expert, this is not a reasonable mistake. Sometimes reasonable mistakes are made, but this is not one of them.
Perfect.
Right? Look at that.
You are absolutely right. I'm so proud of you.
Virginia bar examiners. Look. Can I substitute this for taking the bar?
I think you should. That's a very, very good explanation of what has to happen.
Look, this is giving Elwood's video essay. I'm just going to send it to them and request they just admit me.
We'll do the Legally Blonde thing.
Really?
Yes, we can do that.
Okay.
We'll try.
Look at that. But no, okay, so that makes sense, is that the idea of, sure, some mistakes happen that are kind of, sometimes shit just happens, right?
Yes, sometimes stuff does happen.
Yes, but there's reasonable and unreasonable sort of mistakes, right?
Correct. Okay. Yeah, it's like you're saying. I think that's a really good point for everyone to know. Is it's the reasonable person standard. What would a reasonable expert have done in that case? Not what a reasonable person would do. You, as a reasonable person, would hire an expert.
Yeah,
would go with somebody in tandem. But what would a reasonable expert have done? And yes, somebody else who's a skydiver, who's an expert in skydiving, would take the stand and say, here are the things that you have to do as a skydiving expert. You need to prepare your parachute in this way. If you haven't prepared it in this way, that's wrong. It's outside of our standard of care. It is not reasonable for this person to have prepared the parachute in this way. It was wrong. It violated this rule, this code, this standard that we have in the industry.
Just medical malpractice with doctors, right? You don't bring in just any person to say, well, reasonable person. No, you say a reasonable doctor would not have done that, would have taken this life-saving measure or whatever, right?
Absolutely. What would a reasonable doctor have done to save the life?
Okay,
would CPR have been performed? I don't know. You and I don't know. Maybe, it seems like maybe you should have done CPR, but a doctor would know, a doctor in that circumstance. So is it an ER doctor, another professional, specialized doctor? What would that doctor have done? If they saw these particular symptoms, would CPR have been performed or not? And if so, an expert would say, I'm a doctor in a similar field or the same field. This is the standard of care. When you see these symptoms, X, Y, Z has to be done. He only did X and Y. Z wasn't done. Right. So he's dead.
Okay, this is totally a random question for you.
No,
it's good.
It's always the random. Go ahead.
Look, it's a good question, I feel like. So because you've been a lawyer for a significant amount of time, you've done well in your field. You could be an expert, right? Have you ever... this is my question. Sorry. Let me...
I love this.
String a sentence together. Have you ever testified sort of as an expert witness?
I have not.
We'll have to add that to the bucket list. If anyone would like someone to testify as an expert witness, I want to watch, but Virginia will testify.
I don't know what I would testify to. It's hard as an attorney to be a legal expert.
Right.
Because most of what I would have to testify about as an expert would be what would a reasonable attorney have done.
Right.
So I don't know if it would be like an ethics breach.
That's what I was kind of imagining in my head was, if someone is saying that, I don't know how that would actually play out.
It's hard. I don't know of many lawyers who are expert witnesses. We usually hire expert witnesses, someone in construction, a doctor, an accident reconstructionist. all of these other people who have expertise in other fields and industries, but the legal industry usually doesn't have experts testifying unless it's some kind of legal malpractice suit.
Or even academia, maybe some sort of like expert in con law, like your dad or something like that.
Right.
It's fascinating.
But I would love to be a witness at some point in my life. I think that would be fun. I mean, not like I'm going to go out of my way to be a witness, but I do think to be on that side of it would be absolutely fascinating.
I have a theory, not about you in particular, but I just think having an attorney as a client or as a witness would not be as fun as you would think.
It's not.
Right.
And I have hired a few attorneys of my own for various reasons in my life. And I don't envy my attorneys. I really don't, because I feel like I know things, right? I know how to do it. I'm an attorney. I know what to do. I can go in and represent myself, but it's really not a good idea.
What's the adage? A lawyer who represents himself has a fool for a client, right?
Yes. And I would be a fool. I don't know things about education law. I don't know anything about education law. Now, I know how you should do it direct, but I don't know anything about education law. So I need an education attorney. I don't know how to draft my own business agreements. I have an idea. I think I know contracts fairly well enough, but for the specific language that needs to be in there, there's someone who knows it more. Right. There's a business law attorney who's been practicing business law a lot longer than I have.
Right.
I'm going to consult them, but it's hard.
But the attorney that you had as a client was a really nice client, even though
yes.
So embarrassing. I did not know she was an attorney. And I'm just calling her, this is Chelsey from blah, blah, blah office. And discovery is a legal term. But I proceed to explain to this woman in the most just layman's term.
Which is what we normally do. Most people don't know.
Right. And she, again, so nice, let me completely get through my spiel. And then I'm asking her the discovery questions. And I'm like, where are you employed? And she says, lead counsel. And I kind of think, and I'm like, oh no. I have just, it would be like talking like in baby talk to somebody who is just like a linguistic expert. But she was so nice about it.
She was. And you don't know. And most of our clients are not attorneys. So you did exactly what you were supposed
and she let me completely, I guess good practice, but she let me get through my spiel about what discovery was.
Sweet. I had one. My favorite was I had, on behalf of one of my clients, I had filed a suit against another driver, a car accident case, and the driver was an attorney. Okay, the defendant was an attorney. And let me tell you, that deposition was one of the best, most interesting depositions I have ever done in my life. I'm trying not to curse here. So the guy was an absolute jerk.
Really? I mean,
he kind of like me. He thought he knew what the law was and what it should be and how he wasn't negligent. So in the deposition, he presented as a pompous, arrogant jerk.
Yeah.
For his presentation. So you tailor your questions and your attitude and your appearance and your own presentation to the people that you're talking to. And so I went into the very nice mode of, oh, okay, well, that's really interesting. Would you tell us more about that? And this guy, the more he talked, the more arrogant he became, the more jerkish he became. And by the end of it, he seemed like the most arrogant fool who there ever was. And we settled. There's an attorney representing this attorney, and I'm an attorney cross-examining an attorney. So everybody's an attorney in the room. But within weeks, I talked to the attorney representing the attorney, and I was like, look, your client is not a good witness. No. The judge and the jury are going to hate him. And it's not because he's a bad person.
And the way he comes off.
Right. He seems like he really is a good, competent attorney. But because he's an attorney and because of the way that he's approaching it as an attorney, he looked like an awful person who really had almost purposely caused this injury. And it's not like he purposely caused the wreck, but the way that he came across was so poor that it just ended up settling because that was how he presented.
Yeah. I think it's interesting, a small part of what you said of so you said, I changed my technique on how I'm asking questions. This is something I learned recently in one of the trial skills courses I've taken, was the presenter. I don't know what just happened.
The presenter. Go ahead.
The woman speaking. She called it very similar, but what she called it was like the Columbo approach, is that she said she just pretended to be, because I think of cross-examination a lot of times as this really intense, like if you think Legally Blonde with like Chutney on the stand of like, didn't you, like that whole like very intense.
And it can be.
And
there are great times to do that. But really good times.
But that's what she said. She was like, that works occasionally. She's like, my default is the Columbo. It's really disarming to people who are kind of being more aggressive. Is they're like, oh, can you tell me more about that? Just kind of pretending to be clueless, essentially. And that it kind of puts the other person off of their like aggression, and then it works really well. And that's kind of what you're saying of just like the feigning interest almost.
Let them dig their own grave, so to speak, is let them bury themselves. One of my favorite, that was one of my favorite depositions, but one of my favorite uses of my own Columbo moments is I look like I'm 17. Let's be honest. I am not. I'm over 40, but I really look as young as the number of years that I've practiced. So when I go in, and attorneys who don't know me, they've never seen me, they think I'm the intern or they think I'm a brand new attorney. And I use that sometimes. And one of my favorites was an attorney who came in and he was blustering of, I'll do this and I'll do that. Oh, okay. Well, that's concerning. I don't know that I want you to do that. Well, I'm just going to take it to trial. Okay. All right, let's do that. And then we go to trial, and for that particular trial, I mean, it just creamed the poor guy. As it was a smashing success for me in the courtroom for a trial.
Right.
And the guy he had no idea what had just happened because he made a poor assumption.
Let the assumptions work for you. I mean, there's no point in refuting, like you said, lean in.
Yeah. So it was like Columbo. I act like I don't know anything. I act like I'm brand new and I have no idea what's happening. And, this is very scary for me is, oh no, please don't take it to trial, when it's absolutely the thing that I want more than anything. Yeah, please, let's go to trial. Bring it on. But that's
so funny because like, again, that's like your expertise. Like, I mean, that's what, like, you are so good at trials. That is what you practiced, undergrad in law school was trial stuff. Yeah. And so for that, just to me, that's very entertaining. Just the thought of somebody being like, well, I'm going to take a trial. Oh, okay. Bet. Game on.
Yeah. So for those of you who meet me later, I'm happy to go to trial. I really am. I won't tell you that, but I really don't mind.
The legal strategy here, I love it.
It is. It's a lot of legal strategy. So when you bring a negligence case, you want to make sure that you have an attorney who understands legal strategy, understands the elements, the things you have to prove for a negligence case, and is able to walk a judge or a jury through those 4 pieces to prove your case. Yeah.
I think that when you summed it up, perfect. Find an attorney that you trust, who you think is going to be able to do that well. Look at that. I feel like we covered a lot today.
I think we did. So back to the basics. Here we are, the Law Unscripted, going back to the basics. We've now hit the elements of what is negligence, how do you prove it, and hopefully shown you how you might be able to be successful in bringing a negligence case with a good attorney.
Yes. We hope you enjoyed it. I hope you learned a lot. If you have any other questions about something we covered, something we can elaborate more on, please drop them. Don't forget to like, comment, and subscribe. There's a new podcast on the Law Unscripted every Tuesday, and every Friday you can join us for the Legal Weekly Wine, where we cover sort of the latest and greatest legal headlines and dive into those. But we're so glad to have you all joining us, and we really appreciate any, feedback that you can give us. So
any suggestions as to something that you want to know, because this is truly about everything you don't know,
don't understand,
and no one ever told you.
Right.
So anyway, have a great day. Happy New Year. And check us out for Tehrani Law, because you never need a lawyer
till you do.